morning docket. Case number 110835, State of Kansas v. Morrison.
May it please the Court, the State of Kansas appears by Stephen Obermeyer. Mr. Chief Justice Nuss, may I reserve 3 minutes, please, for rebuttal?
3 minutes is granted.
I'd like to take 20 seconds of my initial time to explain my mayhem-like appearance from the insurance commercial, and I'll do that in the form of a public safety announcement by saying that May is Bicycle Safety Month, so if you're going to ride a bike, even if you're not going very fast, you should wear a helmet, which I didn't do. The issue in this morning's case on petition for review from the Court of Appeals addresses what is misconduct in office for an elected official, and also addressing the standard of review concerning sufficiency of evidence or elements of misconduct in office. This is an ouster appeal. I don't think the court sees those very often. They used to be original actions in the Kansas Supreme Court, and a lot of the older cases you will see are from the court acting as the trial court, basically. The court, I'm sure, is familiar with the facts that are set out in the briefs and in the Court of Appeals opinion. Just procedurally, this was the events occurred around Halloween of 2012. In January of 2013, an ouster action was filed by the state. The judge convened an advisory jury to get their opinion, and then following their verdict, the judge wrote a 25-page opinion, which is in one of the appendices. The defendant had no objection to any of the jury instructions, and the jury found that David Morrison engaged in willful misconduct in office and willful neglect of duty in giving his city hall key code to a longtime friend who was down and out and having drug problems, so this person could spend the night at City Hall for several nights, and allowed him access to people, items, and documents that were not accessible to the public, and failed to perform duties entrusted to him under the Prairie Village Municipal Code. The jury did not find a violation of crimes involving moral turpitude, trespass, theft, and the official misconduct criminal statute. There was a post-trial letter by defense complaining about the willfulness instruction, and then Judge Halber wrote his judgment of ouster. So on appeal, the issues raised really were not seen by Judge Halber as far as this language from State versus Duncan, a 1931 case that worked its way as syllabus 4 in the Court of Appeals opinion. And basically it interprets misconduct in office and neglect to perform any duty as requiring a persistent and habitual disregard for the law or for the public official's public duty, or acts so egregious that they pose a grave threat either to public safety or to the public fisc. This certainly is not in the language of the statute as far as misconduct. There's definitions in Black's Law Dictionary as far as what misconduct is, or I think Random House setting out what neglect is.
And in 1931, there was not a statutory definition of misconduct, was there?
No, there was not. There was not back then. And this court has said in the past that if the legislature intended to do that, make it persistent and habitual disregard and egregious acts that pose a great threat, and it's only available in circumstances that show corrupt purpose or an evil design, that under any reasonable interpretation of the language used, they should put that in the statute. And so this case is a good opportunity to define what misconduct is. There's some language in the briefs from
Is that our job, to define misconduct?
Well,
if we have a statute that sets forth that misconduct or ouster is justified by 1, 2, 3, 4, why isn't that the test of misconduct that would justify ouster in the statute?
The statute does, you mean the 4 different options for ouster, the
Right,
willful
I'm
misconduct.
just asking, you're saying it's up to us to define misconduct. I'm saying, why isn't it the legislature's responsibility to define misconduct if they're going to have a statute that says you can oust her for misconduct and then describe for circumstances that support it? Because I see that the problem here is whether the Court of Appeals made the definition that was contrary to what the legislature said. That's the real issue here,
Right.
isn't it?
Yes, and it's not defined
So
by the legislature. So in not doing so, I think we can look at what the common definition of misconduct would be. And that's why I cited the Black's Law Dictionary that says misconduct is a dereliction of duty, unlawful, dishonest, or improper behavior, especially by someone in a position of authority or trust. And that neglect, from the Random House Dictionary, is to disregard or slight, to omit through indifference or carelessness, to fail to take or use, to fail to carry out or perform. And we certainly know by Monday morning, after Malone had spent 2 nights in City Hall, that Councilman Morrison called the chief of police to talk about his friend who may have a hit out for him by people who were trying to hurt him or worse, has a drug problem, and what he could do. But he doesn't tell the chief of police that, oh, by the way, he's got my passcode into City Hall, so he can go in there at any time. So that would be a disregard and failure to carry out a duty to advise that somebody can be back in City Hall there.
Well,
and then this all came.
Go ahead. No, go
This
ahead.
all came to a head, I guess, on Halloween morning. I think it was the 31st, where you have Malone in the break room, the employee break room in City Hall, and the women come in to get their coffee or put their lunch away, and here's this person, that's when the chief finds out, and it becomes an issue.
Didn't the Court of Appeals, instead of going to Black's Law Dictionary or other source like that, what they did was synthesize what prior cases had said, what rises to misconduct or neglect, and attempted to utilize that as a source for the gauge in which we would look at what the actions would be measured against. That kind of, isn't that what they did?
I think they looked at some of the older cases which talk about misconduct and use that language. And I think they, I don't know if the Court of Appeals cited, you had an opinion when you were a district court judge, and just made the observation that a lot of these cases involve, grave misconduct and the things that are set forth in the syllabus. However, that doesn't mean you have to have persistent and habitual disregard for the law. It doesn't have to be a repeated misconduct, because the statute uses it in the singular, that it's a misconduct. So our argument is that if that might be the way that it comes up in these prohibition cases where the mayor or the chief of police aren't enforcing the law, that doesn't make an element or a requirement to be misconduct.
Do you agree Morrison could have slept there himself?
I don't know if the records show if he had an office. There was a city council chamber, and I know there's several photographs in the record on appeal that you could check, but if he was there as a city council person, then yes, he could have been there for work, working on city council projects, and if that involved sleeping so he could work some more, then I would think so. And that was the cover story that he used to get his friend in there, that, he's here for a homes association meeting that we have on a Saturday night back in City Hall.
So it's not okay if his electricity is out in his house and he just needs some place to stay with electricity?
Well, the ethics ordinance talks about not granting a special consideration, treatment, or advantage to any citizen available to that which is available to every other citizen or granting an improper favor, service, or thing of value. So I think if he's there for something work related, that would probably be okay, but not to bring somebody else there when you're not working on anything related to city hall business. And also, it wasn't anything related to his job as a city councilman to vote on issues as far as zoning or street widening or what have you. He'd have to have the consent of the other, I think, 10 members of the city council to have somebody stay there.
What does it mean then if we're talking about who can or who can't, and what's willful and what isn't willful neglect? And the last paragraph of the judge's memorandum decision says there obviously could have been a different view of what happened October 27th through October 31st if the person Mr. Morrison sought to help was an abused spouse seeking sanctuary. Would that have been okay? Would we be here today if that were the situation? I mean, does it depend on the person? Does it depend on the circumstance?
Judge Halbert doesn't answer that. I guess it might get closer to the line, but because you're still granting a favor to somebody, regardless,
Right.
where there's other options. But he goes on to say that more importantly, is the laws are not intended to be ignored, bent, or selectively enforced, which is what happened by granting this special favor. The councilman owes the citizens a fiduciary obligation to protect city property, staff, and citizens, all of which could have been jeopardized by a thoughtless risk to which Mr. Morrison would not subject his own family. And I guess another difference between a abused spouse and Malone was the abused spouse doesn't have a hit out for, isn't using methamphetamine, snorting heroin, and you don't know what's going to happen if you just leave her alone the next morning with the people in City Hall.
But the point, as I see it, that abused spouse is still using public property for personal use. It's not a hotel, it's a city hall. And would the abused spouse be okay if you gave him a patrol car and says, here, drive to the shelter? I mean, whether they're using city vehicle or using city property as a hotel, it's still utilizing city property for personal use.
I think the
Right,
problem.
I agree.
If I can add on to that, the problem I'm having is figuring out what duty are we talking about? And so if you can help define that in answering Justice Johnson's question, I think it would assist
Sure.
me.
The duty would be prohibiting a city official from permitting the use of city-owned vehicles, materials, or property for personal convenience, except when such services are available to the public generally, which is in the city's code of ethics under the misuse of property code. So that would apply to the abused spouse situation, absolutely. The other provision of the code says that a council member cannot grant in the discharge of his duties any improper favor, service, or thing of value, and the city doesn't allow members of the public to sleep in City Hall after hours. In fact, there had been a snowstorm or something a year earlier, and people could stay in a city building during the day, but they had to go home at night. So those were two of the things I think that the district court cited, as well as granting special consideration, treatment, or advantage to any citizen beyond that which is available to every other citizen.
So would both the misconduct and the duty that you're talking about be tied to the code of ethics? Or is there anything beyond that? I mean, at one point in your argument, you mentioned a duty to disclose. I don't know that that's necessarily in the code of ethics.
I thought I would think as far as just taking care of city property, that he should have told the chief of police that you need to cancel my access codes because this person is going to go in by himself. And when Malone told Councilman Morrison that, I might spend the night here on Tuesday night, Mr. Morrison just said, that's not a good idea, but didn't bother to tell the chief of police to cancel his code or tell the receptionist from the police department to not let him in. And sure enough, he comes in carrying a notebook and acting like I'm coming in to do city business, and Mr. Morrison's right behind me, and that didn't happen. And I think that was part of the neglect and not making them aware of that.
If we look at the two-prong,
Excuse me. Go ahead.
Go ahead.
okay, if we look at the two-prong test that the Court of Appeals used, if in the second test they had put the act in the singular so that it would be an act that is so egregious that it poses a grave threat, would their test be wrong?
I think it would still, if you just have act so egregious that it poses a grave threat, I think it would still be wrong just under what a general definition of misconduct would be. I think under syllabus 4 that nobody could be ousted under that standard. But certainly, the district court didn't have a chance to consider this as the law because that was never presented to him as being an element, and it wasn't in the jury instructions proposed by the defendant either. But I don't think that's because the court said that in some cases dealing with prohibition that would be the case. And there is a case where the sheriff allowed a friend of his, instead of spending the night at jail, to go home and clean up and change clothes, and the Supreme Court in that case found that to be judicial ouster was appropriate in that case. So that's a little bit similar here. But if you look at all the cases,
But in that case, he always has to keep him locked up. Where do you draw the line when the word is convenience? Isn't it a convenience for somebody when you're even doing business to sit on the couch? Or to get them a pop?
yes, I guess there is some different levels of convenience, but in this case, it was just more than, he wouldn't let Malone stay home because his mother might catch something, but I don't know what he has, but I'll let him stay at City Hall and those people can fend for themselves. So maybe there is a sliding scale, but it is still granting special consideration to somebody that nobody else could have unless they have access to City Hall after hours.
Justice Breyer, you still have a question?
Just very quickly, I think I got a little confused about your answer regarding a duty to disclose, which I assume was a reference back to what you said earlier about talking to the sheriff. I understood that testimony really to go to his concealment and his knowledge of inappropriate behavior. That and the testimony about what he told the person who sat at the entryway next to the door. And my understanding was there were two different incidents where he spoke to two different people in that position and said, there's X excuse for why this is occurring. But you're saying that can also go to this idea of a duty to disclose to safeguard city property?
Well, on Monday morning, Councilman Morrison talks to the police chief about his friend and wants Malone to come in for an interview because he has all these issues going on.
Right. And he fails to mention he's been sleeping at
Correct.
City Hall.
Well, and fails to mention that, by the way, he's got my key pass to get into the City Hall at any time, and it needs to be revoked.
I understand that. I understand
Okay.
the fact.
Okay.
I just, the way that you were suggesting that fact was relevant, it seemed different to me today than what I understood from what I read. I thought that it was more relevant to his knowledge that it was wrong, rather than this idea that he had a duty to disclose at any particular point.
Well, the cover story to get into City Hall, I think, shows his knowledge that it was wrong every time that he went in there with that.
Okay.
But Councilman Morrison said, well, I didn't tell the chief because that wasn't a police matter, that was a council matter. And of course, nobody on city council knew about that either.
if another councilman or councilperson had known that Mr. Morrison was sleeping there, even though he had, Mr. Malone was sleeping there, even though he had Morrison's keypad, would they have a duty to disclose to the chief of police or others?
If they knew that somebody was using city property,
I think that's what we're getting to. Is there a duty to disclose simply because of having the knowledge that somebody's sleeping there?
I would think so, Justice Johnson, just because the Code of Ethics begins with that your conduct should be above reproach in your actions in faithfully discharging the duties of office, and the public interest is your primary concern that they should have. But when the city council did find out about this at one of the meetings, they did not vote for just a censure. They voted that ouster proceedings should be initiated, so they were pretty upset about that.
Have you looked up the word reproach lately? Just
I
out
have
of
not.
curiosity? No, nor have I. It just strikes me that as human beings, no one's conduct is ever 100% above reproach. I mean, it's kind of like you can sue about anything. You can also reproach someone about anything, can't you? Anyway, thanks.
Briefly, Chief, I'd like to just add, if you could talk about the standard of review and what you
Yes.
believe the standard of review is.
Sure, just
We're out of time.
yes,
But you could just run through that for me.
just briefly, the Court of Appeals characterized this as a question of law, that there were no disputed facts in this case, and I don't know why you have a 3-day jury trial if there were no disputed facts. The jury was instructed in Instruction 9 that Morrison contends his conduct was not intentionally or purposefully done to cause injury to another or to do wrong, but was based on humanitarian motive. Jury Instruction 12 told the jury that the good faith of the defendant can be a factor to consider, and the jury rejected that. And so I view this as a sufficiency of evidence issue as opposed to a question of law. And when you apply these rules on sufficiency of evidence, that you don't get the result that you do in the case that the Court of Appeals cited, which dealt with trial court suppression of evidence, I think.
Could I'm sorry, were you done? On that same issue, this court in the Cahill decision from 1977 said something that I'd like for you to tie into your response. And it says that actions in the nature of quo warranto are now generally held to invoke the discretionary powers of the trial court, and thus the grant or denial of relief rests within its sound discretion. So can you weave that into your answer about whether this is a sufficiency of the evidence standard of review, or whether it's discretionary or
Well,
combination or something else?
Right, and I, under Cahill, which was an ouster action, they did say it was kind of an abuse of discretion standard. And so I cited Cahill in the brief, as well as a case dealing with, I think it was where you have clear and convincing evidence what the standard is, a BDY, I think it was a parental termination case. But that's by statute that the standard is clear and convincing. This is kind of by common law. But Cahill definitely says that it's an abuse of discretion standard. So that's way different from the Court of Appeals citing Poteet saying it's a question of law, that because you have to give the district court some deference to when they see all the 20 witnesses or so and the 100 exhibits and everything. They've been there, and usually the court says we can't tell from a cold transcript what happened at trial. And so the Cahill standard had been the law in Kansas on ouster sufficiency since 1977. Yes.
I'm still a little unclear then, if the evidence is sufficient to support findings, how does discretion by the trial court fit into that?
Well, I'm assuming in Cahill, was that the BPU people falsifying their expense reports? I think I mean, I guess it fits in because if they found it was sufficient evidence that the court didn't abuse its discretion in deciding on ouster. I'm not sure, but I'll try and come up with an answer for you.
No, and as I understand it, what the trial court did also was find that there was, rather than the burden, rather than being a preponderance of the evidence, it would be a higher standard given what ouster implies, and it was a clear and convincing standard that was utilized rather than a mere preponderance of the evidence.
That's correct. That was the standard employed by Judge Halber.
And I guess I'm trying to figure out how discretion can come into play at all when the statutory terms are mandatory. If this, then you shall forfeit office, you shall be ousted. So it does seem to me to be, do these facts fit into the first part of the equation? Because once we get to that answer, then we know what the rest of the story is.
And I don't know, Justice Boz, if that just means that once you find sufficient evidence for ouster, whether it's discretionary, whether the judge actually does that or
How
not.
can it be? It says shall.
Well, yeah, that's true. The statute does say shall. And under the more recent definition of abuse of discretion, I'm not sure if you could still look at that under Cahill and say, well, you still have to look at the elements. The legal standard, that's one of the three ways to abuse discretion, is to not follow the statute. So,
But to follow up, it's not just the judge shall, the statute says that the person shall forfeit such person's office. So these actions operate as a forfeiture. And the ouster is just a enforcement of the forfeiture, if you look at statutory language.
I think that's true. Once you find that misconduct, then they shall forfeit office. That's correct.
So how does discretion enter into that?
It under the fact that if a court found all the elements but decided not to forfeit office, that would be an abuse of discretion under the plain language of the statute, I think.
All right, very good. Any further questions? Thank you, counsel.
Thank you.
May it please the court, Rex Sharp on behalf of Councilman David Morrison, now the president of the Prairie Village City Council. He did nothing here that was willful misconduct. This case should never have been brought, and the statute is fairly clear. It does not talk about misconduct. This is not an ordinary misconduct case, as was briefed by the state, referring to the Nebraska unemployment case or the Texas firing of an at-will employee or a Texas firing of an appointed municipal person. This is an elected office. This is a statute that is clear, not ordinary misconduct, not knowing misconduct as they use in Tennessee, but willful misconduct that has been defined by this court for over 80 years, and the legislature has never intervened and said, that's not the right definition. The proper definition is pretty simple. It is, there must be an act, and that act of misconduct must be a grave danger to public safety, something that is likely to recur, or it can be loss to the public fisc for personal gain, an evil type corrupt motive in the public fisc area. Those are the areas that we're talking about. We're not really talking about the crime of moral turpitude. Obviously that could be an act and it's another part of the statute, but that's not part of this case.
Counsel, my notes indicate that Kennedy was decided in 1910, is that right?
Yes, Your Honor.
And Duncan in 1931?
That's correct.
And when was KSA 60-1205 passed?
I do not know the answer to that, Your Honor, but it's
After these cases were decided?
after those cases were decided, but its predecessor was the Unfaithful Servants Act, which is basically the same thing. And all of this case law has come before, as well as after this particular statute has been enacted. And it all requires, and for good reason it requires, something more than simple misconduct. Otherwise, almost every elected official could be called on the carpet for simple misconduct, because what you may view as misconduct, I might not view as misconduct.
How do we get away from the language in the statute, engage in misconduct?
It says willfully engage in misconduct.
But it seems to me the question is, what is misconduct?
It could be, but it's not simple and by itself. It is willful misconduct. Willfully engage in misconduct, not simply just engaged in misconduct, because that would read out a large part of this case. And if you did that, almost every single instance of any type of conduct, some people voted in favor of a certain position, some people voted in favor of a different position. One might say that's misconduct, while the other one said, no, I thought it was proper conduct.
Well, I know that's what you want to say, but let's break that into two parts. There's willful engagement, and then there's misconduct. So let's concentrate on the second element, which is misconduct.
Okay.
And I know you want to say it's simple misconduct does not qualify, but it doesn't say gross misconduct or exceptionally bad misconduct. It says misconduct.
You're right. It doesn't say ordinary misconduct. It doesn't say knowing misconduct. This court has construed that language, the entirety of the phrase, not just one word, but the entirety of the phrase, and really the entirety of KSA 60-1205, to require grave problems to the safety or something very serious with respect to the public fisc.
And what is the most recent case where this court did that?
It's been a long time, Your Honor. This court hasn't reached that decision, I don't believe, or reached that issue in 10 or 15, 20 years, as I recall.
Well, there's been an emphasis, as Justice Johnson has pointed out in a number of oral arguments the last year or so, that in recent years, this particular court has really tried to look at plain language of the statute.
And I have no problem with looking at the plain language of that statute. And particularly in the context of KSA 60-1205, grounds for forfeiture of public office, something pretty serious, something before the courts step in to some elected official's position and gets themselves involved in an elected office. Separation of powers comes into play, and this court doesn't jump in because there's another option that's been available, and that is the recall statute, which was last, I believe, amended along with KSA 60-1205. And the only reason for the courts to jump into this elected arena is if there is an immediate need, an emergency that needs to be taken care of by the courts. You can't wait for the slowness of a recall election. This is not that case. There was no safety problem to the public. There was no serious, grave problem of public safety, and there was simply no issue about the public fisc. So whether he had a wrongful motive or a good motive, none of that matters unless you're going to have a public safety issue or you're going to have the public fisc issue. That's the law
I
of
don't
Kansas.
understand that when you say the motive doesn't matter. I understood that the Court of Appeals faulted the district court for watering down the legal standard, and that for ouster to be justified, they must show that there was a evil or corrupt motive. I thought that's what the Court of Appeals said.
The Court of Appeals did that, relying on a long list of cases involving.
Well, okay,
Yeah.
but the point is, does it matter what the motive is?
It can matter. It can matter in the public fisc area.
I thought the Court of Appeals said it must be there.
It must be there if you are concerned about the public fisc issue. But I don't see that in the case law that it needs to be there if there is a grave problem of public safety. Because regardless of your intent, if you continue to put someone in grave jeopardy of their public safety, I don't know that it matters.
Mr. Sharp, what was the evidence about the status of this gentleman's addiction and recovery at the time he was permitted
There-
to sleep into the...
in the
There
city
was
hall?
no great evidence on that. It was the fact that he had been a former meth addict.
As
What-
recently as just a few weeks before, right?
It had been weeks before.
Because I'm just thinking as a person who comes into a building fairly frequently early in the morning, if I were confronted by an addicted person who'd been sleeping outside my office, I think I might be feeling I might be in some danger. That's not enough danger in your view?
I don't know whether you would feel that or not of someone who has, if
Let's
they were
just
currently
assume I would.
addicted. Yeah, if
Let's
they,
just assume I would. That's
Okay.
not enough.
it's probably not enough for public safety issue, a grave public safety concern. Particularly since I would expect in this courthouse, as in that particular city hall, there was well, at least in that instance, there was a police presence on site at the time, and everything was video cameraed. I don't know if that's the case here, Your Honor, but that would not, I don't believe, qualify for grave public safety, but that would be a different case than the one we have here. So given those requirements, those high requirements, the Court of Appeals was correct when it said, we're going to just accept all of the facts that Judge Hauber found. I don't know how you could get more deferential than that, whether that's an abuse of discretion standard or whether we're just going to blindly accept whatever the facts were below. They said that's what we're going to do. You just don't have the evidence that gets into this statute. We don't need to jump in here and do something. That is something that can be done on a recall basis.
But that's only if you add words to the statute, I think. And here's what I wrote the first time I read the Court of Appeals decision. This is before we even granted review. I wrote down, are we showing more deference to the separation of powers by adding words to a statute? And I don't think you can read syllabus 4 as judicial restraint. I think you have to read syllabus 4 as judicial legislating.
I don't see how that's judicial legislation.
Because it's not in the statute.
Yes, but it's also not clear what willfully engage in misconduct while in office, what that means. If this court never had to engage in construction of a statute, that would be great. But there is a purpose for this court. And this court has been engaged in construction of statutes, and this particular statute, for decades. And consequently, that judicial gloss through the construction is something that the legislature is deemed to be aware of. And every time they have an opportunity to look at this statute, they could say, you know what, we think it should be watered down. We think it should be easier to remove elected judges or elected city councilmen or just elected anyone. They could have done that. They could have said, let's just strike out the willfully engaged in misconduct. Let's just take it as misconduct in general. And if you did that, then there would be no need to even get into the neglect to perform anything or anything about crimes of moral turpitude, because I would assume that would be encompassed into the broad misconduct. They could have watered it down like the district judge did, but that hasn't been done. The legislature hasn't chosen to do that. After all, they're elected officials, as well as there's a number of elected judges now. Even on the Court of Appeals in the Kansas Supreme Court, there are efforts to make those elected positions. It can't be that simple. It has to be something in which there's an immediate need for the courts to jump into that election fray. And that is not this case. The reason this court and most courts have held that the courts don't jump into the elected fray is they're supposed to be out of that elected position, out of that election process. Let the voters decide. If he did something wrong here, and he's already said, I was just trying to help somebody who was homeless, I didn't use the best means. I made a mistake. He said so.
If he had said, I'm just going to help this homeless person and here take the city vehicle and use it for a couple of days instead of using the city hall as a hotel, it would have been the same in your estimation?
It would have been. It would have been something that would have possibly violated the municipal code, and the
if he had
municipal
taken
prosecutor could have dealt with that.
Had a credit card in the glove box, he'd taken it and gone to Florida, it still would have been okay.
Now you're talking about the public fisc issue. And that's a
where do
different
you
issue.
draw the line? How much use of property would be de minimis in your view?
Well, in this particular instance, it didn't cost the city anything, so that would certainly be, a zero is de
That we
minimis.
know of.
That we know of, and
That we know
they
of.
would have presented evidence had they been able to show any loss to the public fisc. I don't know where the courts would draw the line, whether that would be $100 or $1,000 or $100,000, Your Honor, but in this particular situation, it doesn't rise to the level of the state, bringing the power of the state to be in an election process.
Was there a difference between misconduct and unethical conduct?
Absolutely there is. And that is one of the reasons why the local code can't be used by the state as an effort to modify KSA 601205 and water down what is misconduct. If you can redefine misconduct to be something that's simply unethical, you've gone as far down the list as you can possibly go. And thankfully, that's not the law. The statute doesn't delegate to cities, to every single city throughout the state, the ability to amend that law. The state gets involved. The power of the state gets involved when there's a state duty that's been violated. And that state duty is something that's fairly high, as it should be. That state duty is something that this court has pronounced over the last almost 100 years. And there's no reason to change that. The Court of Appeals, quite frankly here, got it correct. And their opinion really, because it's very deferential to the district court and says, here's the synthesis of the law, and there's good reason for it, that Court of Appeals opinion should be affirmed. And it could even be adopted in toto by this court because it addresses the pertinent issues. We would ask that the court do exactly that, and that the district court be continued to be reversed as it is, and the Court of Appeals be affirmed in all respects. Thank you.
Any further questions?
Do you think the word willful requires bad faith?
I don't think it necessarily requires bad faith on the public safety issue, as I indicated. It does require some type of evil or corrupt motive, and it's usually for personal gain in the public fisc area. If you're pocketing money, if you're stealing money from the state, that is a serious issue, and that is one that I think gets into the evil or corrupt motive that the Court of Appeals was talking about.
And so in the ouster arena, we would apply a different definition to willful than we do in the criminal arena?
I think you would have to apply a similar definition, but you would have to consider the entirety of the statute and read it within the confines of that entire statute, along with the fact that the recall statute has its own type of language in it that allows for some of this lesser conduct to be handled by the electorate, and courts only jump in when it's necessary.
Here you're saying we're talking as a matter of statutory construction.
Correct, Your Honor.
That here you want us to read willful as malicious.
I don't think it needs to be malicious, Your Honor. I don't think willful needs to be malicious, and I don't think that's the way in the civil context it's read. I think it's more intentional type language. But nonetheless, it's certainly not the watered down definition that the district court used of simply indifference.
The act was intentional here. I mean, he didn't accidentally give him the code or accidentally put him there or accidentally permit him to live there for a number of days. It wasn't an intentional act.
And in that respect, you get through that intentional act issue. But the misconduct, the combination of willful misconduct and the entirety of the statute gives the gravitas that you have to have something serious and grave here before you get to an ouster level. And this just didn't get there.
Isn't that what the district court spent 3 days doing? Is that it had this allegation of misconduct and neglect, and it tried to determine the best it could how, by the evidence, and does this fit within the statute? And that's basically, the court looked at that, applied a clear and convincing standard, and found that it did.
No, I don't think the district court did that. I think the district court did something a little different than that altogether. The district court utilized an advisory jury and wrongfully instructed that advisory jury.
Which there were no it seems to me that's an advisory jury, doesn't have much capacity, but that's
really
beside
doesn't.
the point. But
It was simply really a cover situation for, if I instruct the jury this way, I'm going to get a result that I want. And it was almost a virtual directed verdict, no great surprise. And so he's got cover, and then he finds the way he believes the willfulness and the willful misconduct is so watered down that he can find it if he wants, and he did. And the Court of Appeals simply said, you can't do that. You might have the evidence, and we're not disputing the evidence, but it doesn't rise to the level that's necessary for all of our elected officials to have to go to court and be ousted. That's something that we're going to leave the electorate to decide whether they should recall him or not.
At times, it seems like you've directed us to willfulness, and at times you've directed us to misconduct. So if I can parse that to make sure I understand what you're talking about, how would you define willfulness?
How would I define willfulness? In this context, I would define it as the court has defined it over the years. I would combine the willful and the misconduct in the entirety of the statute, and reading it as a whole, as I think the court generally does, I would say it requires two things. Or one of two things. It requires either a grave safety or public safety
focus on
issue.
willfulness for me, if you would, please.
Willfulness is I would go back to what was proposed by the in the district court by Dave Morrison's counsel at the time, and that was that it was intentional or purposeful misconduct.
And how did the district court not apply that?
It used in instruction number 11, it talked about indifference and doing wrong. And
But
isn't
that misconduct?
that type of language, indifference, is not intentional or purposeful. Indifference, I'm indifferent to whatever somebody might do, is not the same as I'm intentionally or purposefully trying to get that done.
But how does the evidence not support that this was an intentional act, as you were asked earlier?
It depends on what you mean as intentional. If it only has to be something that is, I wanted it to happen and I moved it forward so that it could happen, that would be intentional. But if you say that's all that's required, then you've read out of context the misconduct part. So it's intentional wrongdoing that is all that is important here. And this particular person did not have an intent to do wrong. He had an intent to find housing for a homeless person. Not something that anybody contends is wrong. It's something that everybody contends that's not the proper means to do it. You could have done that and would have been great, and everybody here would have said, if you'd taken him to a church, great. But you didn't. You took him to a city hall, and that's the improper, wrong way to do it. And so you're subject to recall if you do something that is wrong like that. You use the wrong means. For instance, I think Justice Johnson said, you used public property without authorization. You couldn't do that. You can't do that, and we think you're subject to recall as a result. It's not subject to an ouster, but subject to a recall.
What would have added the missing element here so this action would have risen to the level of, as you say, wrongdoing, which makes it misconduct?
The type of misconduct that would be necessary here would be stealing from public money, using public money. For instance, stealing thousands of dollars to give to this person so he could go buy something.
What would be the minimal addition to these facts that it would rise to the level of the misconduct required by the statute?
I don't know if I can tell you what the minimum would be, but it would have to be something where the public fisc was at issue and the likelihood of recurrence was high. There was no likelihood of recurrence because the access code had already been taken long before any of this ouster proceeding started. And I'm pretty sure, given what the mayor did afterwards, that the chief of police would not have turned a blind eye to a guy going past the dispatcher and seeing on the videotape that he stayed there every night. So I don't think the recurring issue would have been there. I think there would have had to have been something that shows that the public fisc was at risk and that there was a possibility of recurrence, that there was a safety problem, public safety problem, and a probable recurrence issue. Neither of those existed under the facts here. So I don't know what else there would need to have been, but there would have had to have been at least those kind of facts. Public safety at risk, likely to recur, the judiciary needs to step in. Public fisc is involved, corrupt motive, likely to recur, and we can't wait for a recall. Again, the judiciary needs to step in and do something. They can't let that continue. That's not what this case was about, though.
Are you suggesting under the facts of this case, a reasonable person could have thought it was legal?
Could have thought it was legal?
Legal and reasonable.
Certainly, somebody could have looked at it and said, perfectly fine to let somebody sleep over there. Others would have said no, but I think almost everyone would have said, that's not a good idea.
But we've got a consciousness of guilt here because he lied to get him in and he concealed what he was doing. Most people that think it's perfectly innocent conduct don't go out of their way to hide that conduct.
Let me address that cover-up issue, because he wasn't ousted because of this cover-up, but it comes out in spades, I think, in this particular case, at least to this court. This cover-up issue is not something that was hidden or not obvious to everyone that was involved. The dispatcher, when he came by and said, oh, this is going to be, somebody's going in with me for an association meeting, the dispatcher didn't believe that. The dispatcher knew right away that's not the case and told her boss. Boss did nothing. They're watching on the videotape day after day.
That isn't the point. That isn't the point. The point is that he took steps. Even if he wasn't believable with his cover-up, he took steps. And to me, that shows a consciousness that this isn't innocent behavior.
I didn't say it was innocent behavior. It was behavior that he said it was wrong. I shouldn't have done that. And so he owns up to that, and I'm not going to say anything different. He said, I shouldn't have done it. He apologized to the city council, and they have accepted his apology and now have promoted him to be the president of the city council. So there has been no recall effort as a result of these facts, and there shouldn't perhaps have been. But if there was going to be, it should have been mounted in the context that you just described of this is not something that we should tolerate, or is it? And has he been sufficiently punished by having to go through this entire process? And he was suspended for a period of time by the city council. He's now back on that city council and is an effective member of the city council. And we would ask that he remain so and that this Court of Appeals opinion be affirmed. Thank you.
Any more questions? Thank you, counsel. You're reserved 3 minutes for rebuttal.
Thank you. I'd just like to address a couple of issues. As far as the willfulness jury instruction, defendant proposed one. It's at page 171 in volume 1. It says willful conduct is intentionally or purposefully doing wrong or causing injury to another. That instruction was given to the jury in instruction number 8. It mirrors the defendant's proposed instruction, and that's at volume 1, page 78. So they got the willful.
Mr. Obermeyer?
Yes.
That issue was before the Court of Appeals.
Yes.
It declined to address it, correct?
Correct.
Okay.
That really was the only issue that was objected to in front of Judge Halber, who addressed it when he wrote his ouster opinion, which, by the way, included the fact that I recognize there's a higher standard of proof in quo warranto actions. That's at pages 6 and 7 of his opinion. He definitely is aware of the higher burden in ouster opinions. Whether there's a recall election or not, there's still the statute, and as Judge Halber said in the opinion, I just can't ignore the statute requiring forfeiture of office if these things are done. In addition, Farmer versus Rutherford is in the blue brief. It's a 1932 case. The court said an act done by a public officer in direct violation of a statute regulating his official duties is official misconduct within the terms of his bond. there is no authority to be allowing people to be the city's innkeeper and housing people in City Hall. He wouldn't even bring Malone home to his own house or stay in his own garage or maybe where he worked.
And as a factual matter, previously he had put this gentleman up in a hotel at his expense,
Yes.
and he chose not to do that this time. So his personal benefit is he saved the hotel bill this time.
At least 3 or 4 nights of hotel bill. That's correct.
But can I ask you, as a practical matter, if this council voted to institute ouster proceedings, but subsequently allowed the gentleman back on the council and elected him president, what's the point? I mean, why are we here arguing about this?
Well, I think there was testimony that usually the most senior councilman is the president, number one. Number two,
But how did he get back on the council? If he was ousted?
after the Court of Appeals opinion came out, they ordered him put back on the city council, and that was back in October or September or October. So that's why he's back on the council.
But under our rules, if we grant a petition for review, the Court of Appeals opinion is suspended or of no moment.
That's true. Rule 8.03 says that. So,
But anyway, the council chose to give effect to that opinion.
the Court of Appeals issued a separate order putting him back on the city council after the opinion came out.
Okay, so that was by
Before
order.
the petition was granted?
It was within 2 weeks after the Court of Appeals opinion came down.
Okay.
Do you think there's any merit to using the statutory definition of the phrase misconduct in office as it appears in the recall statute to apply it to the ouster provision? And just to help you, subsection B of 254302 says that the term misconduct in office means a violation of law by the officer that impacts the officer's ability to perform the official duties of the office. So I guess my question would be kind of, if we add the word willful to that to be intentional or purposeful, can't we just use the legislature's own definition of misconduct in office and then apply that definition to whatever the facts are here?
I don't. Because there's 3 or 4 different subsections of under the we have misconduct. I think they could. I think if they don't define it in the statute, that we go with what the common definition of misconduct is, and as opposed to what's in some other statute.
Yeah, I mean, I suspect Mr. Morrison would say no, that these statutes have different purposes. One's recall by the voters, the other's ouster by a judicial order, and so we need to look at them differently. But there's, it's sort of the same thing, and we have a definition here, and we don't have a definition
Correct.
in the statute we're dealing with.
And there's also a misconduct in office criminal statute too, so it would be confusing as to which one to use.
Could you respond to your opponent's argument that we should not look to the Municipal Code of Ethics as a standard? We should look only to state duties under state law?
Yes, in the initial blue brief, I think on issue 2, we addressed this issue raised for the first time on appeal by saying that cities have a charter ordinance, or they can enact their own codes, and if they want to require ethical conduct, they should be allowed to do that.
So they can impose a higher duty than state law would under what the legislature would have recognized when they passed the ouster statute?
Well, if you had the same actions under state law, I'm not sure if there'd be a state statute that would cover the concealing to get into City Hall or anything. It might be criminal. I mean, moral turpitude for crimes is a separate subsection. But I don't think that would apply.
I'm sorry, I thought you were still answering Justice Luffert's question, so maybe I misunderstood your answer. Are you saying it is or is not proper to use the municipal code as a basis for the ouster?
I think it is
You did.
proper to use it is proper to use the municipal code for ouster, and I guess that should apply. You have municipal ordinances, traffic violations. Why would that not be a law? And that's under subsection 2, the omission. Under the misconduct, there's not a state law argument in that situation. I think that's all the comments I have.
So if we, let me understand, kind of getting back to Justice Johnson's observation here, if we reverse the Court of Appeals and affirm the district court, Mr. Morrison will be ousted from his position as he now sits.
Yes,
There hasn't been a subsequent election in the meantime.
not until April of 2016.
I'm just curious. All right, thank you.
That's correct.
Okay.
And so I would ask that this court either do that or give Judge Halber a chance to consider these arguments and legal issues that have been raised for the first time on appeal.
What would be the purpose of sending back to the trial court for legal argument?
Well, if you affirm syllabus 4, I guess that none of that was presented to Judge Halber in the jury instructions, proposed jury instructions. If that's the standard and you affirm the Court of Appeals, then he should get a shot at that.
You're saying the Court of Appeals opinion raises other factual issues that the advisory jury, neither the advisory jury nor Judge Halbert considered, is what you're saying?
Yes, I raised invited error, issues raised for the first time on appeal. That got bypassed and we got to the syllabus 4 issue, yes.
For instance, whether there was a selfish motive.
Correct, which was reclaimed as casuistry, I think, in the opinion. I think they're reweighing the evidence. It's not a question of law, but yes, that's one example too.
Any further questions? Thank you, counsel.
Thank you.
We thank you both for your arguments this morning. Court will take this matter under advisement. We now